As the courts have continuously said, it's the responsibility of Congress to pass laws dealing with Indian issues, and they have responded through the years with several significant pieces of legislation. The court's endorsement of tribal sovereignty in Crow Dog was in large part responsible for passage of the Major Crimes Act by Congress in 1885. Under the act, 7 major crimes, if committed by a Native American in Indian country, were placed within federal jurisdiction, regardless of whether the victim of the crime was a Native American.
The Major Crimes Act is an evolution in itself too as well. It evolved over the years. What it is it gives jurisdiction to the U.S. government in forcing criminal laws upon natives within Indian reservations.
This is how I explain it to those who come to work for me, is that the federal government has certain inherent responsibilities to Indian country. One of them is the enforcement of the Major Crimes Acts, which are basically the felony crimes that are committed on any tribal nation or any tribal reservation or lands. With that, it's their jurisdiction. The federal government, meaning the FBI, is the one who's going to handle those cases. Homicide, sexual assault, aggravated assaults, those kind of things. The ones where you're going to end up spending more than a year in jail on.
They are things like murder, manslaughter, kidnapping, all felony assaults, which include domestic violence assaults now, all Chapter 109A offenses, which are basically all of our sex crimes. It also includes theft under Title 18 United States Code Section 661. It includes child abuse. Even though child abuse is not technically defined in the federal code, we are allowed to use state definitions for child abuse. Same is true for burglary. That's another enumerated offense that's included in 1153, but because burglary is not specifically defined in the federal code, we have to look to state law for the definition of burglary, even though we have jurisdiction to prosecute those cases.
There have been those situations where there's 2 non-Native Americans, a non-Native American perpetrator and a non-Native American victim. And if that happens within the confines of a reservation, then we defer it to the county. So for example, when I was stationed down here back in the early 2000s, we were getting a lot of those immigrant body dumps out in Gila River. So we would investigate them because we didn't know whether or not we're dealing with Native American involvement or not. To the point of where we were able to either determine that or not. And ultimately what we had to do in a lot of situations is call the Maricopa County Sheriff's Department and also have them be involved in the investigation in the very beginning, because we didn't know which direction it was going to go. Federal government, the FBI loses jurisdiction whenever one of those elements is not met.
In the sense that the United States Attorney's Office is really the only prosecution show in town, if you will, for felony crimes, for major crimes committed on the Indian reservations, because the state does not have jurisdiction over most of those offenses, and the tribe currently, for most tribes other than those who have the Tribal Law and Order Act felony jurisdiction, the tribes only have misdemeanor jurisdiction.
The General Crimes Act under 1152 is much more expansive. The Major Crimes Act is much more narrowly tailored. And so the General Crimes Act applies more to non-Native American defendants who may commit a crime in Indian country, where we have a tribal member that's a victim.
General jurisdiction crimes are basically crimes that have federal jurisdiction regardless of where they're committed, whether it's in Indian country, off of the reservation. That would include things like drug trafficking offenses. That would include things like child pornography, firearms offenses. Those are cases for which the federal government has an interest despite the location.
The Assimilated Crimes Act allows for federal prosecution of a Native American who commits a crime that is not defined under federal law, but is a crime under state law.
The Assimilated Crimes Act is under Title 18 United States Code Section 13, and essentially what that was intended to be is a gap filler. Basically, what Congress said is that for federal prosecutions, we can assimilate state crimes where Congress has not already spoken. So I'll give you a couple of examples. For instance, in the federal code, we don't necessarily have a criminal statute for driving under the influence, whereas the state does. So we can assimilate state crime because Congress has not already spoken, does not already have a statute in place for DUI offenses. We can use the state statute for DUI in prosecuting federally. There is an argument to be made, although there's probably some disagreement on this. The federal code does not include a drive-by shooting statute. The state of Arizona does have a drive-by shooting statute, so there is some argument to be made that Congress has not specifically spoken in the field of drive-by shootings, and therefore we can assimilate state law under our federal code because Congress has not already spoken.
Burglary is probably the best example that we use because we use it a lot, and we see a lot of burglaries that occur in Indian country. And when we charge those cases under the Assimilative Crimes Act, we simply charge the statute that allows us to assimilate the state statute, and then we charge the state statute just as you would if you were charging it in state court.
The Indian Civil Rights Act of 1968 said tribal governments cannot enact or enforce laws that violate certain individual rights. It makes many, but not all, of the guarantees of the Bill of Rights applicable within the tribes.
The Indian Civil Rights Act of 1968 basically afforded most of the Bill of Rights that we have under the United States Constitution to Native Americans as well. One of the distinct differences that we notice, particularly those of us who work in the criminal field, because we're so accustomed to the Miranda warnings that are given to our individuals who are arrested and who law enforcement wants to interrogate. And they are told that they have a right to remain silent, that they have the right to an attorney, and that if they can't afford one, that one will be provided to them free of charge. So while the Indian Civil Rights Act provides for a right to remain silent and a right to have an attorney, it does not provide for the right to an attorney to be provided to you free of charge. So it's one of the real distinct differences that we have, and sometimes, not to get off on a tangent, but sometimes it can create some issues for us in our federal prosecutions, because if an individual has only read their Indian Civil Rights Act by a tribal law enforcement officer and they're not told that they have the right to an attorney free of charge before questioning, that's not consistent with the Bill of Rights under the United States Constitution, and we could have issues with any statements taken thereafter.
The important thing is what the offense is you're making the arrest on. And since they're being arrested on the state or local charge, the Miranda rights that you would normally give for that state violation would be what you'd give. Now, the only time that would change would be if they had also committed some other offense once they got back on Indian country land for which that officer didn't have jurisdiction, but a tribal officer might. So a tribal officer investigating that other offense might necessitate that they actually give them their tribal Miranda warnings for that.
When we know that there is a federal investigation, typically tribal law enforcement will turn it over to the federal law enforcement officers to conduct those types of interviews. Or if there are tribal law enforcement officers who are investigating federal crimes under SLEIC authority or other deputization that they receive from federal agencies, that they get in the habit of reading the United States Constitution Miranda warnings to individuals who are being investigated for federal or potential federal violations. Now, if they're only being investigated for tribal violations, like a public intoxication or a disorderly conduct or something over which the federal government doesn't have jurisdiction, then they would likely just read them their Indian Civil Rights Act warning. What I would want to say selfishly as a federal prosecutor is this: if there is any indicia that this is going to be a federal investigation or federal prosecution, read the rights under the Miranda warnings of the United States Constitution, including the right to a lawyer free of charge.
The Indian Civil Rights Act, it has limitations. The biggest limitation is that you can incarcerate an individual up to 1 year. Then beyond that 1 year, then it becomes a U.S. Constitution issue.
The Indian Child Welfare Act keeps American Indian children with American Indian families. Congress passed ICWA in 1978 in response to the alarmingly high number of American Indian children being removed from their homes by both public and private agencies.
The tribes have jurisdiction over Native American children. And with that, there have been a lot of cases within the last 10 years that ICWA has been applied to the lineage of the child. Let's say a Native American mother gave up her child at birth to adoption through the state agency because she didn't live on the reservation, had a child, and decided she couldn't care for that child. Years later, she could come back and say that because I'm a tribal member, this child is Native American, and that child needs to learn about where they come from, their heritage, and their lineage and whatnot, and she could actually, you could use the Indian Child Welfare Act to get that child back, which would be in the best interest of that child to be raised on the reservation or by the biological family. But let's say that we had a child that wasn't an enrolled child member. Let's say 13 years old decided, I want to know where I came from. Everybody says I'm Native. What is my true lineage? Where did I come from? And or the tribe has an issue with the way that child is being taken care of. Then you would end up, the social services could look into the matter and determine whether or not what's in the best interest of the child.
The Indian Child Protection and Family Violence Prevention Act established the procedures for dealing with child abuse and family violence. It specifies certain actions, such as the creation of databases, establishes treatment and prevention programs, and allows for technical assistance, such as forensic investigations.
So the Indian Child Protection and Family Violence Prevention Act really was geared towards providing federal funding for victims of child abuse cases.
Basically establishes the Indian Child Abuse Prevention and Treatment Grant Program. So those tribal nations can get those grant funds to help them not only investigate, but provide treatment options for cases of child abuse and neglect. Additionally, they also require tribally operated programs to protect Native American children and reduce incidents of family violence. So, the domestic violence incidents where children are involved.
It assisted them with setting up child protective services, with setting up multidisciplinary teams to address those issues involving children and family violence.
This act will provide funding for the tribes to receive training, any type of help, resources, they'll assist with that.
Congress recognized the severity of violence against women and our need for a national strategy with the enactment of the Violence Against Women Act in 1994. This landmark federal legislation's comprehensive approach to violence against women combined tough new provisions to hold offenders accountable with programs to provide services for the victims of such violence.
VAWA, the Violence Against Women's Act, was around for a while, but in 2013 it was reauthorized. And wasn't just reauthorized, it was expanded, and expanded pretty significantly. And what Congress did in 2013 under the Reauthorization Act is they essentially said to the tribes, look, if you do, there's certain procedural steps that you have to take to be able to exercise this jurisdiction.
They have to have trained lawyers, attorneys to do the prosecution. They have to have trained judges, and they have to provide trained public defenders, and these are actually law-trained public defenders, because many of the cases, many times on tribal or Indian country, their public defenders are not actually attorneys. They're more legal advisors and counselors. But under VAWA, for the tribes meeting those requirements and others, they have to publish their laws. They have to. It changes the jury pool. So it has to be a mix of non-natives and natives that are part of the jury pool. So if they meet those requirements, then they can actually prosecute non-natives, prosecute and jail, imprison non-natives for violence against women.
If we had a non-Indian who committed domestic violence upon a tribal member, and the state is not going to be where we're going to charge that domestic violence crime out at, because of the victim's status. The victim is a tribal member. So the state's going to say that should be in tribal court. Tribal court doesn't have the jurisdiction to adjudicate this offender. So then we're going to take that case into the federal court. That's where the Assimilative Crimes Act is going to come into play. That's where you can take that state domestic violence charge, assimilate it under the federal code, and prosecute it in the federal court system.
What VAWA did for us is it expanded felony jurisdiction for us in allowing us to prosecute individuals who commit domestic violence crimes, resulting in substantial bodily injury, which is a much lower standard. It also allowed us to prosecute cases involving domestic partners, involving strangulation and suffocation, which we see so often in these domestic violence cases, and we didn't previously have a statute to address those particular crimes.
One of the areas in dealing with the VAWA Act is the full faith and credit section. And I love this full faith and credit section because basically what it does, if you have a domestic violence act and the female Native American wants an order of protection, she's granted the order of protection, and maybe she lives on the reservation, but she works within the city limits of Chandler. She can take that order of protection from the tribe, and it should be used as face value in the Chandler area.
There is a problem with domestic violence and violence against women in Indian country. There's no doubt about that. But how you deal with that becomes a decision that has to be made by the law enforcement who's investigating it, and how that case is going to be presented to whomever involving that individual.
It works within the United States, all 50 states. If you have an order of protection in California and she goes to Maryland and the defendant follows her to Maryland and she has that order of protection and she shows the Maryland police, they should look at that as full face value, and they should follow it and as if it were their own protection order.
We were quite pleased that the Pascua Yaqui tribe in Tucson was one of the 3 tribal police agencies nationally that was chosen for I believe it was a 3-year pilot program. They did very well in that pilot program. They've gone all over the country providing information to other tribes who are interested in reaching those levels, those qualifications to prosecute non-natives. And it's kind of an erosion of the Oliphant decision, and I think it's something that a lot of the tribes are very interested in. It requires a lot of resources to get their tribal attorneys, judges, and public defenders trained and to meet all the federal requirements. But agencies are anxious to do that to protect their people.
We've been given powers of arrest and power to prosecute non-tribal members where there is a physical crime against a tribal member and there's a domestic relationship between the two. We can actually arrest them now and prosecute them in our courts. And we were one of the first tribes to adopt that new law. But at the same time, it doesn't cover everything. Like I said, the relationship has to be domestic. It has to be a physical act. Arguments don't count. Throwing things doesn't count. So there are certain criteria, but it has drastically improved our ability to kind of deter that kind of behavior and actually get some justice for these victims that weren't getting it before.
The Tribal Law and Order Act of 2010 expanded the punitive abilities of tribal courts across the nation. The law allowed tribal courts operating in Indian country to increase jail sentences handed down in criminal cases over Indian offenders.
The Tribal Law and Order Act of 2010 was put into place really to address the public safety needs in Indian country. What it showed to me was that Washington, D.C., and our nation's capital was really taking an interest in what was going on in Indian country. And there are a number of different aspects of tribal law and order. But essentially, I think what the most popular outcome of Tribal Law and Order Act is it allowed certain tribes, again, meeting certain criteria, allowing for the rights that are afforded under the United States Constitution to actually prosecute felonies tribally.
That they were now going to allow the tribes to exercise jurisdiction to prosecute individuals and sentence them for up to 3 years on an offense. So those areas that we would think of as felonies now, because the punishment could be up to 3 years, they could now have jurisdiction over. And secondly, that they could actually sentence consecutively on 3 of those offenses. So if you had 3 offenses, you could essentially stack 3 and 3 and 3 and sentence someone in tribal court for up to 9 years.
Most tribes are misdemeanor courts. So basically what this is doing is it's bringing felony to tribal land where they can be tried on tribal land instead of going to the federal entity, and the tribes can try them and sentence them and house them on the reservation.
The tribes had to establish, essentially adopt the due process that we have in the federal system. They had to create new criminal codes. They had to provide law-trained lawyers to represent these defendants. They had to provide law-trained judges. And so all that had to go on. In order for the tribes to do this, what essentially had to happen is they had to go back and rewrite their criminal codes. They had to write their laws of criminal procedure, rewrite those rules of criminal procedure, and then they also had to publish those things. The community had to know, so that you didn't have defendants who claimed, I didn't understand that I could get sentenced up to as much as 9 years. So they had to provide notice to the community.
There are a number of reporting requirements that our office and other agencies have to comply with. It just really it trended towards a focus in Indian country and showing that we were really taking an interest as the federal government in ensuring that public safety on our Indian reservations is improved.
It's still in the beginning stages. There I think, are 2 tribes that are actually working with the TLOA, but it's a long process. And the reason is because you have to give due process to the defendants. And that would mean you have to get state, certified defense attorneys, and a lot of them don't want to work in Indian country. So, it's new. It's still new, and I think it would be great for tribes, but there's a lot of work that needs to be done for that to happen.
It definitely means that we have to work closely with our tribal counterparts, and it means we have to have good working relationship with the tribal prosecutors, because usually in these cases, even though we know that the case law said that there's no double jeopardy and we could prosecute them federally as well, the reality is that there just aren't sufficient resources to tag team someone and do them twice. So it's really incumbent on us to make sure that we work closely with the tribal prosecutors, figure out where the best jurisdiction is to get the best result and what that's appropriate under those circumstances.
This concludes Unit 4 of this training. Upon completing the Unit 4 assessment module, we'll take a closer look at the culture and traditions of Indian communities, as well as some of the myths that may surprise you. You will now be automatically redirected to the Unit 4 assessment module.